Hello everyone, this is Jenny M. Kagape from BSA Section 812 and I am the assigned reporter of Interpretations of Contracts from Articles 1370 to 1379 of the Civil Code. So more particularly, I will be discussing the definition and the rules of interpretations of contracts. So the first thing, we need to know the definition of interpretations of contracts. So it is the process of determining the meaning of the terms or words used by the contracting parties. Interpretation is the process of making something understandable that was previously incomprehensible, misunderstood, vague, or not readily apparent. It is a way of determining the meaning of a language. Reformation, on the other hand, is an equitable remedy in which a written instrument is made or construed to express or conform to the party's true intentions. So what are the applicable provisions of the Civil Code on interpretations of contracts? So Articles 1370 to 1379 of the Civil Code cover the rules of interpretations of contracts under civil law. So the first rule states that literal meaning controls when language is clear under Article 1370 of the Civil Code. So valid and enforceable contracts, being the private laws of the contracting parties, should be fulfilled according to the literal sense of their stipulations and as they appear in the face of the contracts. So the words used therein should be given their natural and ordinary meaning unless a technical meaning was intended. So if the terms of a contract are clear and unequivocal, the parties are bound thereby. So ibig sabihin, kung malinaw naman yung contract, yung words or terms na ginamit, at tugma siya sa true intentions ng parties, hindi na siya need na i-interpret pa kasi malinaw na siya and yun lang yung ibig sabihin ng rule na to. But if necessary na gamitan siya ng malalalim or complicated words or kaya phrases, saka lang siya need na i-interpret. But kasi usually simple words lang yung ginagamit sa contract, but still it's up to the contracting parties pa rin. So for example, so the provision in the contract giving the vendor the right to repurchase the property sold after 2 years from and after the execution of the contract simply means the vendor can redeem the property after 2 years and not that the right must be exercised within the 2-year period from the date of the execution of the contract. So it is clearly stated na yung vendor, marirepurchase niya lang yung property pagkatapos ng 2 taon, not within 2 years. So, there's nothing to interpret pa because the contract is clear naman. So, next, evident intention of parties prevails over terms of contracts. So, when the words of a contract are clear and readily understandable, there is no room for construction. It is a cardinal rule in the interpretations of contracts that the intention of the contracting parties should always prevail because their will has the force of law between them. And all the words, not just a particular word or two, and the words in context, not words standing alone, must be looked into. So, ibig sabihin, if nagka-conflict yung words or clauses sa written contract or written agreement with the intention of the parties, the intention of the parties shall prevail. Meaning, mas masusunod yung true intentions ng parties. So, dapat pala in the first place, itugma talaga yung kung ano yung true intentions ng parties sa written contract para ma-avoid yung conflict. So, for example, R entered into a contract called Contract of Lease with E, whereby R leased his car to E. It is stipulated that E shall pay 100,000 pesos upon the signing of the contract, and 5,000 pesos by the way of rental on or before the 5th day of every month, and that at the end of the year, E would become the absolute owner of the car. The contract fixed the value of the car to be 160,000. It is clearly stated that the intention of the parties is that the contract is not a lease of a car but a sale on installments. So mali yung nakalagay sa written contract which was called contract of lease. Kasi yung true intentions naman talaga ng dalawang parties is sale on installments. Thus, kung ano yung evident intention of the parties prevails over the terms of contracts. So what else? Contemporaneous and subsequent acts of the parties must be considered in order to judge the intention of the contracting parties under Article 1371. Where the parties to a contract have given a practical construction to the terms thereof by their contemporaneous and subsequent conduct as by acts in partial performance, such interpretations may be considered by the court in determining its meaning and ascertaining the intention of the parties, when such intention cannot clearly be ascertained from the words used in their contract. So the courts are not bound to rely upon the name or title given the contract by the parties. The essence of the contract determines what law should apply between the contracting parties. So next, the special intent prevails over a general intent under Article 1372. So as a rule, where in a contract there are general and special provisions covering the same subject matter are inconsistent. The latter shall be paramount to and control over the former when the two cannot stand together. The reason for this rule is that when the parties express themselves in reference to a specific matter, the attention is drawn to it, and it must be assumed that it expresses their intent. However, a reference to a general matter, which may include the specific matter, does not always imply that the parties had that particular matter in mind. So for example, S sold his house including all the furniture therein. The term all should not be understood to include S refrigerator, which is distinct and different from furniture. Neither it should be interpreted to include shares borrowed by S from C for the reason that they do not belong to S. Ibig sabihin, yung term na all does not necessarily mean na lahat ng furniture na nasa bahay ni seller ay kasali sa pagbebenta. Why? Because there are cases na yung ibang furniture na nasa bahay na yon is hindi pagmamay-ari ng seller, like hiram lang pala yun, or pagmamay-ari din ng kanyang spouse without the consent of the seller's spouse. So next, interpretation of a stipulation with several meaning under Article 1373. So when a contract has multiple interpretations, it should be given such interpretation which would make it effective. As a result, if one interpretation renders a contract lawful or effective, while the other renders it illegal or meaningless, the former interpretation is justified. For example, S sold his parcel of land to B. Now S has two lands, one owned by him absolutely and another land of which he is a co-owner with C. C did not give his consent to the sale. The sale should refer to the land owned by him alone, as this would make the contract effectual. So meaning, your parcel of land na pagmamay-ari lang ni seller, yung pwede niyang ibenta kay B. Why? Because mas effectual kasi yon compared dun sa isang land na pagmamay-ari nilang dalawa ni C. And without the consent of C, so parang mas magiging complicated yung situation. And if we interpret the contract, it will be illegal for S to sell the other land without the consent of his co-owner. So better yung land na mismo sa kanya talaga yung ibenta niya. So what else? Interpretation of various stipulations of a contract under Article 1374. So the whole and every part of the statute must be considered in fixing the meaning of any of its parts, and in order to produce a harmonious whole, all provisions should, if possible, be so interpreted as to harmonize with each other and give effect to all the words, not just a particular word or two, and words in context, not words standing alone. So for example, R leased his house to E. In the contract, it was stated that E should not sublease the house without the written consent of R. Another stipulation therein stated that E should pay 1,000 pesos as additional rent of the month should he violate this condition. E subleased the house without the consent of R. Has R the right to eject E? No, in the light of the clause stating the penalty for the violation of the condition. So, hindi dapat na i-eject ni R si E just because meron si E na violation, which is yung pag-sublease niya ng house. Why? Because merong penalty na binayaran si E, so in this case, dapat na i-harmonize din yung provisions. Hindi dapat i-eject agad ni R si E. So next, interpretation of words with different significations under Article 1375. So if a word is susceptible of two or more meanings, it is to be understood in that sense which is most in keeping with the nature and object of the contract, in line with the cardinal rule that the intention of the parties must prevail. So for example, R lists to E a roof for the purpose of erecting an advertising sign. The contract provides for the termination of the lease by E if the building should be constructed on an adjoining property of such height as to obscure the view of E's sign. There was erected on the roof of an adjoining building a sign which obstructed the view of E's sign. So in this case, the term building, as the term is used in the contract, may be interpreted to include the obstructing sign, having in mind that the nature and object of the contract. So yung lessee or nangungupahan dun sa roof ni lessor is may karapatang mag-terminate ng lease sa kanilang contract because hindi niya makukuha yung goal niya why nag-rent siya dun sa roof for his sign kasi may nakaharang na building or sign sa kanyang sign. Thus, it should keep the nature of contract why contract existed from the start. So next, resort to usage or custom as aid in interpretation under Article 1376. So, the usage or custom of the place where the contract was entered into may be received to explain what is doubtful or ambiguous in a contract on the theory that the parties entered into their contracts or contract with reference to such usage or custom. Courts take no judicial notice of custom. It is therefore necessary to prove the existence of usage or custom. Like any other fact, according to the rules of evidence, the burden of proof being upon the party alleging it. In short, kung ano talaga yung nakalagay na compensation for services, even there is already a usage or custom, hindi ito admissible kasi meron ng fixed sa contract. Because we will only interpret when the contract is unclear, but hindi na kailangan i-interpret if yung contract is already clear. So next, interpretation of obscure words under Article 1377. In the event of ambiguity or doubt, a written agreement should be interpreted contra preferentum, that is, strictly against the party who had drawn it, or given an interpretation that is favorable to the other who has incurred an obligation on the basis of it, when justified in light of the operative of facts and circumstances. The rule in Article 1377 is based on the fact that the party who drafted the contract could have avoided mistakes or ambiguity in meaning more easily than the other by carefully choosing words or exercising a little more care. In general, the party who causes the obscurity acts with ulterior motives. Article 1377 is not applicable when there is no indication that the person who produced the contract took unfair advantage of the other party who willingly agreed to it, and it is written wholly in the language spoken and understood by both parties. These types of contracts are binding as ordinary contracts, the reason being the one who adheres to the contract is in reality free to reject it entirely. If he adheres, he gives his consent. Rules in case doubts impossible to settle under Article 1378. If kahit in-apply mo na yung rules from Articles 1370 to 1377, but hindi pa rin masettle or ma-interpret yung contract and may doubts pa rin, such doubts shall be resolved in accordance with the supplementary rules stated in the present article. So remember, there are three rules: gratuitous contract, onerous contract, and principal object of the contract. So if we are dealing with gratuitous contract, the least transmission of rights and interest shall prevail. So for example, R gave his car to E. It is not clear whether the contract is a donation or comodatum. Is the contract a donation or comodatum? So if we go back to the Article 1378, paragraph 1, the least transmission of rights and interest shall prevail. So in this case, we interpret it as a comodatum or pinahiram lang yung car. So that is the gratuitous contract. So what else? So if we are dealing with onerous contract, the doubt shall be settled in favor of the greatest reciprocity of interest. So for example, D borrowed from C 5,000 pesos at 12% interest. It cannot be determined from the terms of the contract whether the loan is payable in 6 months or in 1 year. So in this case, if babalik tayo sa Article 1378, Paragraph 1, the doubt shall be settled in favor of the greatest reciprocity of the interest. So we interpret the loan as payable in 1 year, not in 6 months. Why? Because it will benefit the contracting parties. Since magagamit ni D yung pera for 1 year, at si C naman makaka-earn ng mas malaking interest for 1 year instead of only 6 months. So both of them benefited the greatest reciprocity of interest. Lastly, the third rule, which is the principal object of the contract. So if we are dealing with this rule, if the doubt cannot be resolved, thereby leaving the intention of the parties unknown, the contract shall be null and void. So for example, S sold his land to B. S has many lands. It cannot be determined which land was intended by the parties to be the subject of the sale. So sinasabi dito na hindi ma-determine ni S yung land na ibibenta niya sa dami ng land na pagmamayari niya. At nakapagbayad na ito si B kay S. Dapat niya itong kunin o isauli ni S yung payment kasi kung i-interpret natin ito, the contract shall be null and void because hindi klaro talaga yung contract. So anyway, that is all the chapter 5 interpretations of contracts. So I hope you learned something in this discussion, and that's all. Thank you everyone.